Hello and welcome to Topic 12, Lecture 2, and in this lecture we're going to be taking a look at the death penalty. Okay, so what are we going to be covering in this lecture? Well, we're going to take a look at the Eighth Amendment, in particular the cruel and unusual provision in the Eighth Amendment. We're going to ask ourselves, how does the court define cruel and unusual punishment, and is the death penalty considered cruel and unusual punishment by the Supreme Court? We're going to be taking a look at two key cases that deal with the death penalty: Furman v. Georgia from 1972 and Gregg v. Georgia from 1976. So let's go ahead and get started. Okay, so the Eighth Amendment states that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. And so there are three different features of the Eighth Amendment, one having to do with excessive bail, the other having to do with excessive fines, and the third having to do with punishment. In this lecture, we're going to focus on the punishment aspect of the Eighth Amendment, but you can read in the textbook more about excessive bails and fines. And so, what constitutes cruel and unusual punishment? How do we think of, we do punish people for committing crimes in the United States. The question is, well, what is a cruel and unusual punishment? And what standard might we use to determine whether a punishment is cruel and unusual? Now, remember earlier at the very start of the semester, when we were applying different legal methods for deciding cases, remember, we looked at the Eighth Amendment's cruel and unusual provision, and we had that hypothetical case about the teen who is going to be subject to a public hanging. And you all, if you remember, you looked at when we're trying to figure out what constitutes cruel and unusual punishment, you could look at, well, like, what did those words mean at the founding? What did the framers intend when they wrote cruel and unusual punishment? You could look back at stare decisis, what have other courts said about cruel and unusual punishment, polling jurisdictions, etc., etc. And so, the standard that the court has used to determine whether a punishment is cruel and unusual, when you're learning about it in the textbook, think about all of the different methods that we learned about earlier in this semester and see what are the provisions that what are sort of the methods that the Supreme Court use in trying to determine whether or not a punishment is cruel and unusual. So when determining whether or not a punishment is cruel and unusual, the court has looked at the concept and applied the concept of proportionality. And so one standard that's used by the court when it comes to considering whether a punishment is cruel and unusual is asking the question whether or not the punishment fits the crime. And so is the penalty, is the sanction for engaging in the action in relationship to the crime itself. And so there's a series of cases that the Supreme Court has looked at. In 1983 in Solomon v. Helms, this was a case about a South Dakota recidivism law. And it was basically, if you were seen as a repeat offender, you could get life imprisonment. And so in this case, a gentleman was convicted for a series of really minor crimes: bad check writing, driving under the influence, and he had collected up so many sort of minor crime convictions that he was ultimately sentenced to life imprisonment. And in Solomon v. Helms, that the court said that South Dakota law was unconstitutional because life imprisonment for 6 minor crimes is disproportionate. The punishment for, writing bad checks, driving under the influence, shoplifting, etc., putting somebody away for life, that's disproportionate, and thus a violation of the Eighth Amendment. Now, in another case, Ewing versus California in 2003, this was a case that dealt with the California 3 strikes law. And in this instance, an individual was given 25 years to life for engaging in 3 serious offenses. And in this case, the Supreme Court said that it upheld California's 3 strikes law, saying that it was proportionate, that for one, they wanted to defer to the state legislature in saying that, let the legislature define what the punishment is. but also that this was about a long history of serious crimes. So when you're committing a serious crime over and over and over again, being put away for a long period of time is proportionate and doesn't violate the Eighth Amendment. And then we get further insight into the case Graham versus Florida. Graham versus Florida is about a Florida law that sentence, or a Florida court that sentenced a minor to life imprisonment without parole. It was about Terrence Graham. He was on probation. He was a minor. He was arrested for committing two robberies, and then he was on probation, and he violated the terms of probation, and that violation of the terms of probation resulted in life imprisonment. And in that case, the court said that that was disproportionate, because it was a teen, that the taking away a teen's life, basically, and putting them in prison for the rest of their life, is not proportionate to the crime. So we get one sense of what's considered a violation of the Eighth Amendment when we think about the concept of proportionality. So what about the death penalty? Is punishment by death considered a violation of the Eighth Amendment? Does execution constitute cruel and unusual punishment? Well, since you know that we use the death penalty today in the United States as a form of punishment, then it's probably pretty easy to conclude that the Supreme Court does not consider the death penalty to be cruel and unusual punishment. Since 1947, the court has held that the death penalty is neither inherently cruel nor inherently unusual. So why has the court ruled that the death penalty is not inherently cruel or usual? Well, one thing that they looked at was the intent of the framers, that when the Eighth Amendment was written, the death penalty was in use as a punishment for crimes. And so if the death penalty was used at that time, then it would be sort of safe to conclude that when they wrote cruel and unusual punishment, that the framers did not mean the death penalty, because the death penalty was being used at that time. Also, the court has looked at the Due Process Clause of the Fifth Amendment, and the Due Process Clause says that your life cannot be taken away without due process. So if due process is followed, then life can be taken from an individual by the state without violating the Constitution. And also they argue that it is proportional. On the last slide, we were talking about proportionality, and that one of the ways that we figure out whether a punishment violates the Eighth Amendment is to say, well, does the punishment fit the crime? Well, as we're going to see, that what the court has said is that when the death penalty is used for a murder, then it is proportionate. But when it's used for things other than murder, that it is seen as disproportionate. Okay. So bottom line is, since 1947, the Supreme Court has said that the death penalty is not inherently cruel or unusual. However, just because the death penalty isn't regarded as inherently cruel and unusual, it doesn't mean that in all uses it's constitutional. Okay. And so that brings us to taking a look at some key cases where the Supreme Court had said the way the death penalty is being implemented and used is, in fact, a violation of the Eighth Amendment's cruel and unusual provision. Before that, let's just do a quick overview of which states use the death penalty and the diminishing use of the death penalty in the United States. So the United States is an outlier in terms of its use of the death penalty. More than 70% of the world's countries have abolished capital punishment in either law or in practice. In other words, they just don't use it in practice anymore, even though they could legally do it. And we do see diminished use of the death penalty in the United States, as you'll see in a moment. 27 states have the death penalty, 23 states do not. And as you know, Wisconsin does not have the death penalty as a punishment for murder or other offenses. We are a no death penalty state. So on the previous slide, I said that 27 states do use the death penalty. And so this map just basically shows you the breakdown, sort of like a regional use of the death penalty. that the states in red are states that use the death penalty. So you can see that death penalty states are primarily in the South and towards the West. The greatest number of executions do take place in the South, currently in the United States. States in the yellow are states that do not use the death penalty. And so you sort of see a Midwestern and East Coast sort of, or Northeastern coast, not using of the death penalty. And states that are in orange are states that wherein governors have placed moratoriums on the use of the death penalty. Can't really see it in this here, but there's a whole United States here. Let me put my magic red pencil on. Underneath here is the United States, but you can see the word federal. The federal government does use the death penalty. So the death penalty is a sentence that you can receive for certain federal offenses. And so this is a graph that shows the number of executions in the United States since 1977. And it's from the Death Penalty Information Center. And I just am showing you this graph because for a couple of reasons. One, it shows the diminished use of the death penalty in the United States. But more importantly, that we're going to be looking at two cases, Furman v. Georgia and Gregg v. Georgia. And so effectively in 1972, the Supreme Court said that the way the death penalty is being used in the United States is unconstitutional. We'll talk about that in a moment. But they said that if certain changes were made, the death penalty could become constitutional. And so in 1976, that's the Gregg v. Georgia case, that the Supreme Court says now the death penalty with these changes that the states have made, it can be re-implemented, it can be used again, that it is again constitutional. And so you basically see that, in 1977, it's that we see a slow upward tick of the use of the death penalty in the 1980s, with a height in 1999 and then a diminished use from there. And so the death penalty is really used a lot less frequently, even though the use of it is constitutional. I also want you to note that, I'm not sure what your perceptions are in terms of how many people are executed each year, but it's a relatively low number with a height of 100 in 1999. But today, less than 40 or people, 30 people are executed nationwide in the United States. So let's move on to take a look at the key cases. So a case questioning the constitutionality of the use of the death penalty in the United States came to the court in 1972 in the case Furman v. Georgia. And as I stated in the previous slides, that since 1947, the Supreme Court has deemed that the use of the death penalty is not inherently cruel and unusual. But a lot of people in the United States didn't agree with that perspective, that they felt that the use of the death penalty was a violation of the Eighth Amendment. And so for many years, those opposed to the use of the death penalty were trying to get a case to come to the Supreme Court so that the Supreme Court could evaluate and rule on the constitutionality of the death penalty and rule about whether or not it violates the Eighth Amendment. And so the case that was brought to the court dealt with William Furman. This was a case about a black man. He was burglarizing a private home. And during the course of the burglary, a family member, the father who lived in the house, he was a white man, that he discovered Furman in the process of burglarizing the house. Furman tried to flee. He tripped, fell, and the gun went off, killing the man. And that, that he was a man and he was father of 5 kids, it was seen as this really horrible death, even though in many ways it was like an unintentional death, right? That it was like, according to the defense, it was an accidental discharge of a firearm. Regardless, William Furman was convicted of the murder, and the jury sentenced William Furman to death. So William Furman and his legal team appealed the verdict in his trial. And it was the NAACP Legal Defense Fund that argued this case before the Supreme Court, or helped in the assistance of the argument with the case before the Supreme Court. And they basically, based on research that they did and presented to the court, they argue that the way that the death penalty is currently employed is that it's employed in a racially biased manner, and that racially biased manner was brought to, like it was represented in this case of William Furman and the accident, the non-intentional death resulting in a death penalty conviction. From the NAACP Legal Defense Fund, they basically said that the data shows that the people most likely to get sentenced to death are Black individuals who kill white individuals. White people who kill white people and white people who kill Black people are a lot less likely to get the death penalty, right? The highest chance and probability of getting the death penalty is when a Black person kills a white person. And so since murder is murder, you wouldn't think that there would be that kind of disparity, racial disparity. And that the Legal Defense Fund argues that the presence of this racial bias indicates that that basically the use of the death penalty is a violation of due process, right? Because some people are treated differently and unfairly than other people. And the Supreme Court agrees with the Legal Defense Fund. And so let's see how they rule in this case. So the question before the court in Furman v. Georgia is, does the death penalty constitute cruel and unusual punishment in violation of the Eighth and the 14th Amendment? And the Supreme Court in a 5-4 decision said that yes, that the death penalty, at least as the way it is currently practiced, is cruel and unusual punishment. As you'll note in the textbook, that Furman v. Georgia was heard with 2 other cases. One was another murder conviction, or a conviction for murder, and that person got the death penalty. And the other case was a conviction for rape, and that person received a sentence of the death penalty. So that there were other cases that were considered in this sort of consideration of whether the death penalty is cruel and unusual. And so that 3 of the justices found that as currently practiced, the death penalty is cruel and unusual. However, with changes to the way that the death penalty is currently practiced and implemented, it could become constitutional. The other 2 justices said that it was the death penalty in and of itself is inherently cruel and unusual. And so that those folks were in the minority, right? But when you add 3 who say the way it's currently employed with the 2 who say it's always cruel and unusual, that's where you get the majority. But it also gives you insight into the fact that the court is unlikely to find that the death penalty is in and of itself unconstitutional. The 5 were really concerned about the arbitrary nature of the implementation of the death penalty sentence, right? That in some states you could get the death penalty for rape, right? In other states you wouldn't get the death penalty for murder. They were really concerned about the racial bias in terms of the implementation of the death penalty sentence as well. But 4 dissenters said that this is a decision that should be left to the legislatures. That if the legislatures feel that death penalty is the appropriate sentence, then that we should leave that decision to the legislatures. But the bottom line with Furman is that basically in 1972, the Supreme Court puts a moratorium on the use of the death penalty. And they say that it can't be used until significant changes are made. So on the basis of the decision in Furman, states listen to what the Supreme Court says, and they begin making changes to their law to correspond with the concerns that the Supreme Court had. And that included the state of Georgia. So what Georgia did is that they the changes that they made were that there were the 2 phases to the trial, so that there was a bifurcated trial. That the first phase of the trial is the determination of guilt, and so that would be the guilt phase of the trial. If the person is found guilty of the capital offense, then there is a second phase of the trial, and that's the penalty phase. So it's like, if the person's found guilty, the next question is, should they be sentenced to death? They felt that dividing it in this way would lead to less of an arbitrary or biased implementation of the sentence of death. States changed their laws to say that only certain offenses were death penalty eligible. That it would have to be a murder that was taking place in the commission of a felony, the killing of a judicial officer, a murder that was outrageously vile. And so basically the types of offenses that were subject to the death penalty were greatly limited to the most serious offenses. In Georgia, the jury decides considering the rules, and then there was some oversight by the Supreme Court of Georgia that reviewed all jury determinations of the death sentence. And so in light of these changes, the court decides to rehear the issue about the constitutionality of the death penalty. And they hear that in the case Gregg v. Georgia. So in Gregg v. Georgia in 1976, the question comes before the court: does the imposition of the death penalty for the crime of murder under Georgia law violate the 8th and the 14th Amendment? And in a 7-2 vote, the Supreme Court says no, that the imposition of the death penalty in Georgia is no longer unconstitutional. They said that they kind of built off of what the court had said in the past, that the use of the death penalty for murder has a long history in the United States, that the history and the precedent strongly supports the notion that the death penalty does not per se violate the 8th and the 14th Amendment, and that looking at public opinion, there is support for the use of the death penalty, and state legislatures want it. So you can see sort of what, some of the different factors that are used in the decision making. But more importantly, that with the changes that Georgia implemented, reducing the arbitrary and capricious nature of the implementation of the death sentence, they found that that moving forward with these changes, the death penalty is constitutional. So where do we stand today on the death penalty? Well, so it seems like after Gregg, the question has been answered, that the death penalty does not constitute cruel and unusual punishment. There's still a lot of opposition to the use of the death penalty in the United States, and that because of that opposition, there have been victories in the Supreme Court from the anti-death penalty folks that reduce and narrow the scope of the use of the death penalty. And so the court has found that certain uses of the death penalty are in fact unconstitutional, that you cannot execute somebody for a crime committed as a juvenile. That is seen as cruel and unusual punishment. And so if you commit a capital offense under the age of 18, even if when you would be executed, you'd be over the age of 18, that is the sentence of death for a crime committed as a juvenile is deemed unconstitutional. That the court ruled that somebody who has a very low IQ or has mental retardation cannot be executed for a capital offense, and that the death penalty cannot be used in non-homicidal cases like child rape. So there are some clear limitations on the constitutionality of the imposition of the death penalty. Well, where do we stand now? Is the future of the death penalty? At least in my lifetime, I don't see the death penalty being viewed as unconstitutional by the Supreme Court. We have a long precedented history of the death penalty being viewed as not a violation of the Eighth Amendment. I think that, when it comes to the use of the death penalty, there may be a social change, right? So that even though the states could use it as a sentence, they may choose not to. And we see a diminishing use of the death penalty over time, as the graph showed. Also, it's becoming more difficult to get the chemicals that are used in the death penalty, because oftentimes those drugs are manufactured in Europe. Europe doesn't use the death penalty, and they're not wanting to transport those drugs to the United States, knowing that they'd be used for the death penalty. So the future of the death penalty sort of probably more resides in social change rather than a change on the ruling of the court. Thanks a lot for listening all semester long. I super, super appreciate it. I hope you learned a lot, and good luck on the final exam. And I will talk to you again soon. Bye.